There are two cases filed by Richard Delasky and Dr. Amanda Odoi against the Anti-LGBTQI bill were earlier today dismissed by the Supreme Court, paving way for the President to sign into law. Both lawsuits aimed to halt the implementation of the controversial bill, citing constitutional violations and potential legal overreach.
The Supreme Court today dismissed two separate cases challenging the constitutionality of the Human Sexual Rights and Family Values Bill, popularly referred to as the Anti-LGBT Bill. The court announced that the full reasons for the judgment will be made available on Friday, 20th December 2024. Media practitioner and private legal practitioner Richard Delasky sought to challenge the constitutionality of the anti-LGBT bill, seeking a declaration that it is null and void, arguing that its passage violated the country's laws and fundamental human rights. However, the Apex Court, presided over by Justice Lovelace Averill Johnson, rejected the petition, citing that the two cases were premature, adding that the constitutionality of the bill can't be determined by the Supreme Court until it is signed into law by the President.
The judgment of the court is unanimous. The plaintiff has been unable to satisfy the first requirement of any party seeking to invoke the original jurisdiction of the Supreme Court. Jurisdiction under Article 2 and Article 131. The invocation of the interpretive jurisdiction is based upon an enactment or any act done under the authority of an enactment. In the instant case, there is not as yet an enactment, properly so called, since the legislative process which would transform a bill into an act with the force of law has not yet terminated. The action, if at all, based on the supposed interpretative jurisdiction of the Supreme Court, is as yet premature, and there is nothing on which to hang the exercise of the judicial review jurisdiction of the Supreme Court.
Lawyers for Richard Delasky and Dr. Amanda Odoi in an interview expressed their disappointment with the judgment, adding that their next line of action will be determined after a thorough assessment of the judge's reasons for the dismissal of their petitions.
The reason of the court. I heard Article 130 being quoted that the action is premature because the law had not blossomed into an act. Therefore, we had no right to come to court. But the bill had not blossomed into an act. Therefore, we had no right to come to court. But please, for now, it is just a tip of the iceberg. Let's get a full judgment. Look at it with the lawyer's lenses, then possibly advise our clients on the next step to take.
Senior fellow of the Accra-based Center for Democratic Governance, Professor Techiwa Menu, also expressed her disappointment with the court's judgment, adding that the safety of persons within the LGBT community was still at a high risk.
Proceeding on procedural grounds, so we still have options. Yes, but as we have said, we will wait to hear to see what is in the judgment.
But when you say options, what exactly are you referring to?
Well, we did not go to court on the contents, on the provisions of the bill. We were proceeding on Article 108, that this is a private member's bill, and based on that, certain procedures needed to be followed. So we want to see what the judgment is and what the arguments have been made.
The Supreme Court has unanimously dismissed a petition brought to it by private legal practitioner Richard Delasky and Dr. Amanda Odoi, challenging the constitutionality of the Family Values Bill. According to the Supreme Court, it cannot pronounce judgment on the matter. That is still a bill until such a time that it's been enacted into law. Reporting for Channel One News, Jude Duncan.